Hello there, I hope you're doing great. So in this video, we are basically going to be looking at an interesting topic, and that is acceptance. So basically, we are going to look at acceptance generally. We are going to define it. We will look at the rules that actually govern acceptance. And then, of course, in between there, we are also going to be discussing a number of very important principles governing acceptance. Hi, how are you doing? My name is Mutiaba Conrad. I'm a lawyer and a private law tutor. And before we start on our class, I encourage you to ensure that you subscribe on to my channel. Just on the lower right-hand side of your screen, there is a red button. Just click on it. This is very important for you so that every time I release videos and classes, this is always brought to your attention. Also share and like this video with your colleagues, just in case you find it interesting, so that they can also benefit. Before we also start on our class, it's important for you to know that in case you're finding law school a bit challenging and you need that professional expert touch, please feel free to reach out to us. Our numbers are down in the description box. You can always make a private arrangement and then we'll be able to help you. And really, these private law tutorial coaching sessions really work, and students already on this program have been proven to outperform their colleagues who do not have any sort of mentorship or professional touch. So let's jump right into our discussion, which is the topic of acceptance. So just to put this in context for you, there is already a class on the channel that is looking at offer, and I encourage you that if you've not yet listened into that class of offer, please, you can first have a look at that after this video. And then there's also already a video on this channel pertaining to consideration. You can also look it up. However, for today's class, we're going to be looking at acceptance. And as I already discussed with you in my first class, that for there to be a valid contract, there has to be offer, acceptance, and consideration. That will make the availability of an agreement. However, for it to amount to a contract, other elements must also be in place, such as consent, the intention to be legally bound, among others. And I encourage you to look at Section 10 of the Contracts Act 2010. It will be able to help you appreciate those principles. And Section 10 of the Contracts Act actually provides for all the elements that must be available in the contract for it to be described as a contract. So there is already an offer, okay, and there is a party that has accepted, okay. But however, for this acceptance to be valid, okay, so as to amount to a binding contract, of course, also consideration must also be part. But specifically for the acceptance to be valid, there are certain legal elements that have to be in place, or there are certain rules that must be adhered to. So if these rules are missing, then acceptance will not be successful, or it will not be valid, and as such, there will not be a valid contract. So it's important for a student to know these rules, and we're going to be looking at them in detail. However, let's first define what acceptance is. And for purposes of definition, I invite you to look at Section 2 of the Contracts Act 2010, which actually provides for the definition of acceptance. And basically, it states that acceptance is an assent to an offer made by the person to whom the offer is made. So that's the definition of acceptance. However, in simple terms, acceptance is the usual thing that you do every day and every second when someone offers to sell you something, assuming Peter asked Jane or offered them to, to buy their pen at 200 shillings. So if Jane replied by yes, or he did an act or omission to indicate that they agree, then as simple as that, they would have accepted. So basically that is acceptance. Also of interest, I also encourage you to look at another definition it can actually be found in Treaty on Contract. And basically in this book, the professor defines acceptance as an unqualified assent to the terms of the offer. So basically, if someone assents, or if someone accepts the offer in an unqualified manner, meaning without attaching any other conditions, then that would be a good acceptance, or that would also amount to acceptance. So let's quickly run and look at the rules governing acceptance. So this acceptance by a party to whom an offer has been made, the acceptance must be within certain rules. And breaching any of the following rules that I'm going to be discussing for you will make the acceptance incomplete or invalid. Okay, so one, the first rule governing acceptance is what this is what is known as acceptance being absolute or unqualified, or others also call it unconditional. So all these words mean the same: absolute, unqualified, or unconditional. Now here what we mean is that if you accept an offer, okay, your acceptance should not have any other terms attached to it. It should be unconditional. So for example, if I offer to sell you my pen at 200 shillings, you should just say yes, okay? And that would be a good acceptance. But the moment you say, yes, I accept to buy your pen at 200 shillings, but only if, okay, I get the money in 2 weeks' time, then that means the acceptance is conditional, okay? Therefore, it will be subject to a condition, and therefore it is not complete in itself. So the acceptance must be unqualified. Do not put any other terms on it. The moment you put other terms on it, then the acceptance is not complete at that material time. I encourage you to go and look at Section 7, subsection 1A of the Contracts Act 2010. It actually provides for that rule of acceptance being absolute. Now, it's important to note this rule under Section 7, subsection 1A of the Contracts Act is also known as the mirror image rule. So if you hear of something known as the mirror image rule, this is what we actually mean, that acceptance must be unqualified or unconditional or absolute. So this is known as the mirror image rule, okay, that the acceptance should reflect the offer. It should be the direct reflection, okay? That is why it is known as the mirror image rule. So in case you find this term, the mirror image rule, should not confuse you. It simply means that acceptance must be absolute and unqualified. So let's proceed to look at the second rule governing acceptance, and this is known, but before we go to the second rule, also on top of Section 7, subsection 1A, you can also look at the interesting case of Hyde versus Range. It's a case of 1840, 49 ER, page 132. And basically the brief facts of this case are that Range offered to sell his farm for £1,000. Okay, now Hyde instead offered to pay £950, which was rejected, and he later on accepted, the £1,000. Of course, the initial the court held that actually there was no valid acceptance. Okay, so I think that case will illustrate the explanation. So let's go on and look at the second rule governing acceptance, and this is that acceptance must be expressed in a usual and reasonable manner, unless where the offer prescribes the manner of acceptance. So when you are accepting, please accept in a usual manner. Okay, don't accept in an unusual manner. Here what we mean, if I offer you my pen, okay, to buy it at 200 shillings, so you can either say yes, okay, verbally, or you can write to me a letter. Okay, that is usual. But if you accept, for example, okay, by writing an acceptance letter, and then you maybe hide it, okay, in a certain house 300 kilometers away from the place where I gave you the offer, and then you accept it, then you think that maybe after 2 weeks I will somehow figure out where the acceptance is. So such a type of acceptance would not be usual. Okay, so that rule is that the acceptance must be usual and reasonable, and accept in a way that is reasonable and usual. Okay, either verbally or in written, in a simple, clear manner. Again, I encourage you to look at Section 7, subsection 1B of the Contracts Act 2010. It actually provides for that second principle. Also of interest to you, I'll share with you the case of Yachts versus Pullen. It's a case of 1975, page 119, SJ 370. Basically, in that case, a part of the terms of purchase of land, acceptance was to be in writing. Okay, so as a part of the terms of a person who was actually going to purchase land, the acceptance was supposed to be in writing, and open quotations, sent by registered or recorded delivery post. So the acceptance by the other party was to be sent by post, okay, and acceptance was sent by ordinary post. So instead, The other party accepted, but however, they sent the acceptance by way of ordinary post. And of course, court went on to hold that there was no valid acceptance because the acceptance was not in a usual and reasonable manner, because the offerer had actually prescribed how the acceptance should be. But when the other party accepted, he accepted, but in a different way as that was prescribed by the person who made the offer. And of course, court went on to state that the acceptance was not valid. So this case actually goes on to illustrate the principle of usual and reasonable acceptance. So let's proceed to look at the second principle, which is actually that acceptance must be communicated to the offerer. Okay, so if you accept, here what we mean is that you have to communicate your acceptance. So don't just say that I accepted in my heart. Okay, but then how would I have known what your heart thinks? I am not Superman. So you're supposed to accept and communicate your acceptance, either verbally or in writing. So that principle can be found under the law. I encourage you to look at section 3, subsection 2 of the Contracts Act 2010. It actually provides for that principle that acceptance has to be communicated to the person who has made the offer. Also of interest, look at the case of Powell versus Lee. It's a case of 1908, 99 LT, page 284. That case actually demonstrates this principle, and in that case, the plaintiff applied for appointment as a headmaster in a school, and it was approved. Now, one of them, without authority, told him that actually he had been approved, but the defendants later changed their minds. So they later on changed their minds even after they had appointed him. So of course, court held in that case that there was no acceptance. Of course, the headmaster later on sued that the committee had accepted to appoint him as a headmaster. But court went on to say that no, there was no acceptance because they did not communicate the acceptance to you. Because he kept on arguing that one of the people who was on the committee actually told him. But court said that no, the communication was never made to you in an official manner, and as such, there was no acceptance, and therefore there was no valid contract. Let's proceed to look at another principle, and that is the principle is that mere inquiries do not count as a rejection. So meaning that if someone is simply making inquiries, those do not count as a rejection. Okay, so if for example you say, Peter says to Jane that I'm offering to sell you my pen at 200 shillings. So if Jane, okay, tries to inquire more about the offer, for example, Jane says that, okay, you're selling me your pen, which brand is the pen? Okay, which color is the pen? So they are simply making inquiries. So those inquiries they are making can never amount to a rejection. So later on, you cannot say, you as the offerer, that actually the offer was rejected simply because someone was making inquiries. So the rule is that mere inquiries do not count as a rejection. I encourage you to look at the case of Stephen versus McLean. It's a case of 1880, volume 5, QBD, page 346. And basically the facts of that case, in response to an offer, the claimant accepted the price and quantity, but wished to know whether delivery could be staggered, okay? And failure to respond to him, okay? So the other party failed to respond to him. He therefore wrote a letter in acceptance. Okay, so he later on, because the other party refused to respond to him, so he later on wrote a letter accepting the offer. Of course, he sued after discovering that the iron was actually later on sold to a third party. And court held that mere inquiries do not amount to a rejection, and as such, there was actually a valid and binding contract. So let's proceed to look at principle number 5, and that is silence can never amount to acceptance. So please note that if someone just simply keeps quiet, if you make an offer to someone, but they simply keep quiet, okay, or they get silent, that does not mean that they have accepted, okay? That's very, very important. So silence can never amount to acceptance. I encourage you to look at the case of Feldhaus versus Bindley. It's a case of 1863, 142 ER, page 1037. Basically, in that case, an uncle and nephew had negotiated over the sale of the nephew's horse, and the uncle had said, open quotations, "If I hear no more from you, I shall consider the horse as mine." Okay. Now, it was sold on auction. The horse was later on sold on auction, and court held, of course, they ended up in court, and court, in its decision, held that silence is not an indication of acceptance. So court went on to hold that the mere fact that someone is silent, this does not necessarily mean that they have actually accepted the offer. Very interesting principle for you to note there. Let's proceed and look at the last principle, and that is that a unilateral offer requires no acceptance other than performance. So the moment there is a unilateral offer, there is something known as a unilateral offer. There's also a class already on my channel on unilateral offers. You can refer to them. But basically, unilateral offers are those that are made generally to a huge number of people. So a unilateral offer requires no acceptance other than performance. So if someone makes a unilateral offer to the whole world or to a magnitude of people which is open, especially if the offer is open and it requires the doing of something, okay? The offer has been made generally and it requires one person doing something. Such a unilateral offer does not require any acceptance, but the mere performance of that thing in itself is a sufficient acceptance of the same. I encourage you to go and look at the Locus Classicus case of Khalil versus Carbolic Smoke Ball Company Limited. It's a case of 1893, volume 1, Queen's Bench, page 256. This case will really help you to illustrate the principle of unilateral offers. It's a locus classicus, really. You cannot be said to have studied contract law well if you have really not understood this case. So please go and read this case so that you're able to pick the principles in the case. But basically, in that case, court held in summary that in unilateral contracts, acceptance is not only unnecessary, but it's also irrelevant, since performing according to the terms of the offer was acceptance itself. So court was trying to say that in unilateral contracts, you actually don't have to perform, okay? You don't have to accept the offer, but the mere fact that you go on to execute, okay, what you have been told to execute in the offer in itself is sufficient considerations. Now, what you have to note here as a side note is that unilateral contracts and the postal rule, which we are going to be looking at as our next point, are an exception to the earlier principle which we looked at, which is that acceptance must be communicated. Remember, we looked at the principle, which was principle number 3 in these rules governing acceptance. We said that acceptance must be communicated to the offeree. Now, just as a bonus for my discussion, I'm also going to share with you 2 exceptions to the principle that acceptance must be communicated. So meaning that there are 2 circumstances where even if you actually don't communicate acceptance, there is still a valid and binding acceptance in the sense. And those 2 exceptions are, one, in unilateral contracts. So for unilateral contracts, there is no need for you to communicate your acceptance. You just have to go on and do what you were told in the offer. That's exception number 1. Exception number 2 is the postal rule. Okay, so even for the postal rule, you don't have necessarily to communicate, and we're going to shortly look at that rule, which actually makes it the last rule governing acceptance. And basically, the postal rule, this states, okay, now this is bringing us to our last principle governing acceptance, which is the postal rule. Okay, so the postal rule, this states that where, okay, use of the ordinary postal system, you know, the postal system where you post letters using posters, okay? So you just drop a letter and then it's transported by either private company or government to the venue where you're sending the letter. So where the use of the ordinary postal system is the normal, okay? Please note here, the words are is the normal, that's 1. 2, anticipated. These terms are very, very important. It must be the normal. 2, anticipated or agreed. Please, okay, this is really very important. It must be the normal. 1. 2, anticipated. Parties must have anticipated it. And thirdly, or it could also be agreed by the parties as the means of accepting the offer. Okay, then the contract is formed at the time that the letter of acceptance is posted, and not when it's actually received. So if parties have agreed that they are going to use the postal system as a means of communicating, okay, and it is the normal, anticipated, or agreed means, it's what parties agreed that will communicate through post, then what is important here to note is that the contract is formed at the time that the letter of acceptance is posted, and not when it's actually received. Meaning that if we agreed to use post as a means of transacting, if I send to you my offer and you accept, okay, the acceptance starts or is valid when actually the other party puts the letter, okay, into transition. It is immaterial whether that acceptance actually takes a year or two to reach you. But the date that we will here look at is the date when they actually sent the letter, not when the letter reaches, okay? Or when it actually is received. Very, very important to note, and that is basically the postal rule. Now, I encourage you to look at the locus classicus case. It's a very interesting case of Adams versus Lindsay. It's a case of 1818. 106 ER page 250. It's the locus classicus. Please go and read the whole of this case. But just to pick out the interesting facts for you is that the seller of wool requested acceptance by post, which was sent on actually the same day, but was never received until long afterwards, after the selling actually of the wool had been sold. Then court went on to establish the above rule, and court stated that acceptance of an offer where parties have agreed to use the postal rule as the normal, anticipated, or agreed means of accepting the offer, then the acceptance of the offer is complete when actually the letter or the post is put into transition, and not actually when the acceptance letter is received. Very, very important principle for you to know and to master at such a tender age. So thank you very much. Basically, those are the rules governing acceptance, and that's all we had in today's class. Again, I encourage you to ensure that you subscribe to my channel. Just click on the red button at the lower hand side of your screen. If you're using a mobile phone, you will have to put your mobile phone in landscape, so for that acceptance, for that subscription box to come. Also, please share and like this video with your colleagues so that they're also able to benefit. And lastly, students interested in private law tutorial sessions, please just feel free to reach out to us. We will always be able to help you. These private tutorial sessions have been proven to work, and students having some sort of mentorship or help have been proven to actually outperform their colleagues who do not have any sort of professional touch. Thank you very much. Just excited and waiting to hear any comments from you. In case you have any questions or comments, please just put them down in the message section, and I'll be able to reply to them. Thank you very much. We meet in another class. Bye-bye.